Mr. Davis?
Madam Chief Justice, may it please the Court, I believe I am here this morning on an issue that, as far as I can determine, has never been presented to this Court before, and one that I believe is of great importance, and one which has led to a steady stream of activity by prosecutors throughout the Commonwealth in trying to determine, after a jury has been selected, whether or not there is a criminal history of any of the jurors.
Can the district attorney check?
No.
Can't do it?
Can't do it.
Why not?
Because the statute limits the people who can check queries on jurors. Chapter 234A, Section 33 is explicit.
Could the DA use another method to check?
I don't know, but he didn't. In this case, he used the method that was at hand, the criminal history check under the statute, and he is not a person authorized to do so.
What would you propose as a remedy for the problem that was posed in this case? Permit jurors to dissemble on their jury questionnaires?
I'm suggesting that in this particular instance, once the jury has started to deliberate, leave it alone. Now, I'm not suggesting that prior to the impanelment or swearing in, okay, whatever you have to do.
Well, either they can do it or they can't. Do they have?
They can't.
Okay.
No, but now you just said I'm not suggesting that prior to impanelment they couldn't check.
They can't. Well, prior to impanelment, we don't know who they are.
Well, are you saying that once the district attorney gets the jury list, they can't check?
That's right. Not under the statute, no.
They can't use Corey to check.
That's correct.
They can circulate to lists to chiefs of police in the county and in their county and say, do you know if this person has a criminal record? And it's sort of like a background.
Well, they could do that, but wouldn't that make for an unlevel playing field? How is the defendant going to do that? We don't have a police department to submit them to and say, would you check to see if this person has a criminal record? And the whole system is based on a level playing field, and that would not present a level playing field. Simple as that. Yeah. Now, it seems to me that...
In any event, I take it, Mr. Davis,
I'm sorry?
that in any event, that's not the case we have to decide.
That's right. That's right. It's not the case you have to decide.
But the district attorney's office is a criminal justice agency, and they have their own power to access information through Corey, do they not?
Not for a deliberating jury. The answer is no.
Okay. How about some Joe on the street? Can they just...
No.
So whether the jury's deliberating or not is not the determining question. I take it your position is, even when they get the list of jurors before impaneling starts, or even when they get the questionnaires, if they could get instantaneous feedback from the commissioner of probation by faxing it in, they still couldn't get the criminal records.
They're not supposed to. And let me add, what happens as a practical matter is when you go in to impanel a jury, each side is given the jury questionnaires. Supposedly, that's the first time we know who is in the venari. The court, defense counsel, and the prosecution. Before that, we don't know. But here they are in the courtroom. We're going to call their names out one by one, or however we do it, and that supposedly is the first time we know who they are.
But you would agree, would you not, that the district attorney can obtain the criminal record offender information of a person on the street, a person they're investigating, just...
Oh, yeah, if they're investigating criminal activity,
so you're saying
yes.
that they could, isn't it a suggestion of a criminal activity if someone is not telling the truth on a questionnaire?
No. At that point, what evidence did they have that there may have been some criminal activity at the time they did it? No. And let me point this out, too. They're doing it now routinely, even though there is no evidence of any criminal activity. They do it routinely once a jury is impaneled. Now, the only thing that's different now than it was then is that at least they're going through the motions of asking the court for permission to do so. And some judges are allowing them to do so, and some judges are not.
Well, that seems perfectly okay, though.
No, it doesn't to me.
Well, the court can do it.
Well, the court can do it, yes.
So the court can authorize the district
But there ought
attorneys.
to be some basis for the request of the court to do so.
Well, let me ask you this, Mr. Davis. How did the foreperson bring to the attention of the court that some jurors during deliberations had strong opinions that about the Boston police that were affecting their deliberations? How did that information get to the court?
I guess it came through one of the notes from the jurors.
Yeah.
Well, you don't guess if the notes are
Well, I do
records
guess
and
because
so-
I'm not quite sure. I think something like that happened, but the notes happened, but I'm not sure it said it in the way you phrased your question. I'm just not sure of that.
Well, what did the notes say
I
from the
don't know.
foreperson?
All I know is that there was some complaint about some of the activities of some of the jurors.
Well, what I'm asking is that the content of the notes might be important because that might be sufficient as a ground for suggesting a criminal investigation.
No, not while they are deliberating. I steadfastly believe, and I think you ought to hold, that you don't interfere with the deliberating jury. Not this way. Now, if there is some evidence, say that, for example, a juror refuses to deliberate, that he is maybe acting weird or she is acting weird, that may form the basis of some kind of investigation, and then you have to move very cautiously. Then that does not authorize you to go run a criminal history check on those people. Now,
Well, it seems to me, Mr. Davis, that the court clearly is authorized to get this information with respect to prospective jurors.
court.
The court.
Right.
And surely the court can authorize the district attorney's office to obtain this information,
Can.
I think.
Can.
But I take it part of your suggestion is if that is done,
Yes.
it should be done not when they're deliberating or after they've been impaneled, but sometime before that.
And it should not.
And it should be shared with defense counsel.
Not only that, the defense attorney ought to have an opportunity to be heard before the judge orders the district attorney to do whatever he has to do in order to get
But in
that
any
information.
event, that didn't happen in
It
this
did not happen.
case.
It did not happen. This came out of the blue. Let me tell you how it came about. Well, first of all, let me say that we were there because of a drive-by shooting which resulted in the death of a 10-year-old girl. And there were two defendants, a co-defendant who was alleged to have been the driver of the vehicle and the defendant who was alleged to have been the shooter. Now, the case was submitted to the jury on December 13th, I believe, of 2004, and on December 21, that jury returned a not guilty verdict as to the co-defendant, and it was then that the prosecutor conducted the Corey check on the deliberating jury and the alternates. Now, it seems to me that that served as a basis for my moving for mistrial because of the timing of it. It certainly indicated to me that there was an intention on the part of the jury.
So it wasn't done prior to the jury reaching the verdict on the co-defendant?
It was done afterwards. It was done the following morning. The jury reached a verdict on the co-defendant in the late afternoon. The court then recessed the jury until the following morning, and it was the following morning while they were deliberating, that this occurred. And all of this came about shortly around about noontime or 1 o'clock, that we were called back to the courtroom and presented with this evidence that the district attorney had run a Corey. And he ran a Corey on it was widespread. Far more criminal histories were brought in than we had jurors because they were doing so only on the dates of birth, and they look at a particular juror and say, he's about the age, so he may be one, let's put him in there. I don't know how many they had, but it was far more than we had jurors, and I do know that in going through them, we determined that, well, this couldn't be that juror because he's too old. This criminal history is for someone much younger. That's the process. The transcript reveals how we did it. And so by the process of elimination, they discovered 4 people that probably fit within the age bracket. And so they decided to, at that point, conduct a voir dire of those jurors that it appeared.
May I interrupt you?
Yes.
At this point, when they brought in the records, did the district attorney represent that they had committed perjury?
Well, that was his representation, but I don't think he meant perjury in the literal sense, because I use the same word perjury, but that was not perjury. I think it was a false statement, maybe, because the statute doesn't speak to perjury in that regard. It speaks to making a false statement for which there's a maximum penalty of a fine of some sort. So we were both using the phrase perjury, but I don't think it was really perjury they were talking about, yeah. But in any event, when I was shown what the district attorney had found, my immediate action was, as the transcript shows, to move for a mistrial. And I moved for mistrial on the basis that there should absolutely under no circumstances like these presented, be any interference with the jury deliberations. And my conclusion, and I think warranted, was that the prosecution did this with the intent that a mistrial be declared. And that is the basis, one of the bases for our being here today. I think that the fact that the district attorney had in mind that a mistrial should be declared is explicit, not implicit, explicit on the record. First of all, he didn't do this until after the co-defendant had walked, if you will, and the jury was still trying to determine the fate of the defendant. And I might add that this case has caused me to rethink about how I present a defense in a criminal case. The defendant here presented an alibi defense. It covered a period of almost 20 hours from the following night up through and past the time that the crime was committed. The co-defendant who was acquitted presented no defense. He just relied on his cross-examination of the witnesses. And I'm beginning to believe now that you're better off by not presenting a defense, because I think jurors instinctively, shift the burden once you present a defense. So that's neither here nor there, but I just thought I'd point that out for your own edification in case, well, you'll never get to try a case again anyway, but that's the way it is, yeah.
Don't count your chickens, Mr.
Yes. Now, one of the things that I think it points to the intent here, not only considering the fact of when it was done, that is, after there had been an acquittal of the co-defendant, but the fact that the district attorney never opposed my motion for mistrial. If indeed he had something else in mind, he would have been yelling and screaming as I was. I was yelling and screaming for a mistrial. He was quiet. He was even asked by the judge, what did he think about the mistrial, and did he ever object? No. He went on to talk about striking at the heart of justice and all of this. And at some point, you'll see in the transcript, I interrupt and say, but you're not answering the question asked by the judge. I have yet to hear an explanation by the district attorney as to why this was done that did not include the fact that they were looking for a mistrial. They wanted me to move for a mistrial, and I accommodated them as I should. And that's exactly what happened. Now, the next thing that happened, the court decided that, we've broken it down now to 4 possibilities. Let's voir dire these jurors. And I said, no, I object. Let's leave this alone. Let's do not interfere anymore with what's going on in that jury room. And once again, it was overruled. They decided to have the voir dire of those jurors. And once...
Let me ask you this. Do you agree with the general proposition that jurors should not give misinformation on their questionnaires?
Well, yeah, but you've seen, I don't know if you've seen those lately, but the ones they were using 2 years ago at the time of this trial, they were ambiguous. It's clearly understood that some of them may have misunderstood what was being asked. I understand now that it has been changed, and maybe it makes more sense, I don't know, for the layman to determine what is actually being asked. But as it turned out, I think they did not understand what was being asked, and their answers reflected that. But in any event, I think not all of them had criminal convictions. Some of them had been maybe arrested and charged, but there were no convictions. I mean, some had been acquitted, but no convictions. And even if there had been a conviction, it would not have disqualified them from serving. So I just think we have to assume that they did not really understand what was being asked, because there's something about being a party to and stuff like that. It didn't ask, have you ever been? You know, language that they could understand. I see that my time is up, and I'll rely on the brief for the rest of it.
Thank you, Mr. Davis. Mr. Zanini?
Good morning, Madam Chief Justice. May it please the Court. John Zanini for the Commonwealth. With me today is Joshua Wall, the trial prosecutor on this case.
Could you just answer my question? Is it in the record how the foreperson brought this matter to the attention of the judge, the matter that some jurors during deliberations had strong opinions that the Boston police were, about the Boston police that were affecting the deliberations?
Yes, in the judge's memorandum of decision, which is both appended to the defendant's brief directly, and also which appears in the defendant's record appendix, which is an impounded record appendix. And in particular, at page 58 of the defendant's record appendix, in footnote 13, the judge explains that on December 16th, the jury foreman gave the court officer a note, and in the note, it expressed the author's view that some jurors believe the defendants were set up by the Boston Police Department. So that's
and was that note shared with counsel?
Yes, I believe it was, and then it was sealed. And the foreman had not disclosed to the other jurors that he was sending this note, so none of the other jurors were aware of it. He was instructed not to disclose that concern to the other jurors. So there was a concern already articulated and recognized by the court and by the parties about what was being discussed in the jury room.
Well, may I ask you about what gave you the authority to use Corey to check on the jurors' records? Where in Corey does it say you can do that?
Well, Corey says that we can use the system, which is a compilation in large part of publicly available data. We can use that point of access in order to have the fastest, most efficient route to what is otherwise fundamentally publicly available.
For what purposes?
For criminal, I'd have to quote the statute.
For furtherance of
criminal.
Necessary for the actual performance of the criminal justice duties of criminal justice agencies.
And was that how Corey was used in this case?
Yes.
In the district attorney's office is a criminal justice agency.
Yes, as is the court.
Mr. Zanini, I confess I haven't read all the cases that you cited in your brief talking about what's going on nationwide on this issue. First, you start off by saying the potential jurors' criminal background. So leaving aside the statutory authorization, just what's happened, you talk about the potential jurors' criminal background, and then there are one or two cases which seem to say that you can even do it after impanelment. Do you know if the courts have made a distinction? In other words, it seems to me that one of the things that one does in going through any jury selection is to have access to as much information as you possibly can about jurors, and provided that the Commonwealth is authorized to use Corey in this way. It seems to me that that's prior to impanelment, and some courts, I gather from your brief, say give it to the defendant as well. That strikes me as one set of circumstances. And then do we know what courts have done after the jury has been impaneled? I mean, there's a Sixth Circuit case that seems to say that, but I don't know about other cases.
Subsequent to the other day, I was doing a Lexus, Shepherds and looking, and I found the Connecticut case where a deliberating juror had a criminal record and was discharged, and there was
do we know how
the parties agreed.
Do we know how that came to light?
I don't recall, and a California case, but I do know in Massachusetts there's two deliberating juror cases where deliberating jurors have been discharged, and they're cited in the brief. And those are Cassidy and Caldwell.
Right, yeah. But that's a slightly, I mean, how, that's not, that's where there was no attempt, if I understand Mr. Davis's argument, he's saying this was a sort of broad sweep at all deliberating and alternate jurors.
Well, yes, but Mr. Davis wants to say that there was some improper motive and intent which is not disclosed on the record. And the judge never inquired, and Mr. Davis never asked the judge to inquire what prompted the inquiry.
Why shouldn't it be too late once the jury's been impaneled?
Well, that's my
Why isn't it too late?
of my question.
For many reasons. If a police officer walked into court and said, that juror sitting right over there has a felony conviction and is statutorily disqualified.
It's too late.
Or some member of the public. But it's not too late. It's not too late to discharge a deliberating juror. And under the common law of the Commonwealth, as far back as the McCormick case in 1881, that was recognized you couldn't discharge a deliberating juror in order to protect the integrity of the court.
And
You have to report that to a judge, and then the judge make a ruling on that? And the judge would decide whether the district attorney should check that person's record to confirm what the police officer is saying.
Well, maybe the police officer walks in with a copy of the record.
Why don't you have the police officers there at the time of impanelment? When they say, the jurors, you read the list of names, have the witnesses there, and if a police officer recognizes a juror as having a criminal record, you tell them then.
I agree. That's a great way to do it. And why doesn't the jury commissioner run the records to make sure that there are no people statutorily disqualified brought in to sit on juries? But it's not happening. So we're in the learning process and trying to get this done.
So how does the DA, if we agree with you, in some cases the DA will check records of jurors and in other cases not?
Well, right now it's being done in our office on all the homicide cases, unless there's a judge who's...
In your office for Suffolk County?
And are you seeking
Correct.
judicial...
But what about Hampden County?
I don't know what they're doing.
And so we would have, in some counties they'll do it, and others they won't do it?
That might be true, depending on the resources of the office and whether it's a homicide case or and
in some counties they'll share it with the defense attorneys, and in others they won't?
Well, I would think everyone would share it with the defense attorneys if they run a record and it appears a juror has criminal history. It ought to be shared with the parties. I mean,
Mr. Zanini, is your office seeking judicial permission?
We are. On the homicide cases, we're filing a motion for leave of the court.
Okay.
And we think that's a belt and suspenders approach.
No, I understand that. In an abundance of caution while this case is pending, of course,
Yes,
that's appropriate.
and some judges, one judge has told us you can't do that, and the other judges say, do what you think you're authorized to do.
No, I understand. Are you doing it on homicide cases or all cases?
Homicides.
And I understand that it may be, that's a judgment call of resources, but there's nothing unique or peculiar about homicide cases except they're very, very serious crimes.
Correct. And we are getting other jurors as we go through this process who have not disclosed. Even with the new form, which is just a checkbox form, I just spoke to a homicide prosecutor this morning who said, oh, sure, people don't check that off. I mean, for whatever their reason is, they're not necessarily checking it off, and we do get some jurors.
Is your position that any misinformation is automatic removal?
No. I think you have to defer to the trial judge's assessment of whether that misinformation both was sort of an intentional withholding or omission, a misrepresentation, as this judge found in this case after a thorough voir dire, and whether it reveals a potential source of bias. I mean, certainly if it's a challenge for cause, and this goes to the issue of, gee, isn't it too late once the jury starts deliberating? Well, of course it's not, because if you can connect a challenge for cause to an actual prejudicial effect, even after a verdict, you're entitled to a new trial.
Mr. Zanini, it strikes me that there's and it may be that there was sufficient cause to look at the entire jury here, but it strikes me that it's a little different if somebody comes in and says, I know that juror, then you have reason to investigate that juror. I mean, you will understand the concern that once the jury is impaneled, there's a lot of jurisprudence that says you close it down, and then from time to time, something happens. A juror says, oh, by the way, I wouldn't ever believe a police officer because, and the foreman brings that, to the attention of the jury.
Well, I would suggest
I mean, the
that,
judge.
there's two statutes, 234-26B
Right.
and 234A-39, both talk about the discharge of deliberating jurors and recognize that it can be done.
No, you
We
can't
just
do
had the
that.
Robinson case.
No, you can do that. The question is, when is it appropriate for anybody, the district attorney or the judge, to order that the criminal background checks be run on all deliberating jurors?
Right. And I would suggest there can't be there is no magical moment or reason why suddenly, because they've started deliberating, now there's a curtain down and you can't
Yeah.
Well, there
check.
is. There is a reason for that, and that's that it could have been done earlier. It could have been done during the selection process.
But it never came to the light of anybody that it was a problem. I mean, if suppose, what I don't follow is this curtain that comes down when the deliberating process starts, because if during the deliberating process somebody suddenly comes in and says, just somebody who was a witness in the case comes into the court or to the DA and says, oh, I forgot to tell you that while I was testifying, I recognized X on the jury. He's my brother's best friend. There would be no reason, even though the jury was still deliberating, that would be brought to the attention of the judge. The person would be voir dire, and most likely the person would be excused from deliberations. So assuming that you have the authority to make the check, which is the question that you have to get over, but assuming you have the authority to make the record check, why is this any different from that situation, which happens routinely?
Right. It's no different.
Well, it is different because you can do the check before the jury is impaneled.
In other
But it's a
words,
huge, you would have to,
It's like making a timely objection.
But in a murder case, you would have to check the entire voir dire, and sometimes it takes days to impanel a murder case. You would have to check the records of maybe 1,000 people.
So isn't it easier to do it then than to do it after the jury's deliberating, or even after the trial started, after we've committed after we've committed limited resources to the trial of a case?
It would be better to do it earlier. And in this case, the judge voir dire 200 jurors and got down to 16 jurors, and then down actually to 15 and at one point to 14. So would it be better to do it earlier in the process? Yes, but the fact that it would be more sensible to do it earlier doesn't mean it's unlawful to do it later.
Mr. Zanini, let me ask you this. Do you attach any significance to the timing here? The co-defendant is found not guilty. That's what triggers the check of the records of the jurors, doesn't it?
No. What triggers the check of the records of the jurors is not on the record because the prosecutor was never asked.
So we don't know. The record doesn't tell us.
You don't know, and I can tell you if you want to know.
We don't know what we're looking at has not been made clear from the record as to what caused.
Let me just say, I don't think it will be helpful, Mr. Zanini, in this case, to go outside the record.
And that's fine.
I mean, my other colleagues may disagree, but at least that's my position.
Right. And I think I've adverted already to what happened. In any event, what you have is a judicial finding. So we're in a situation where you have to defer to the trial judge unless she made a clear error of law or a clear error of fact and drew inferences which she could not reasonably draw on the record. So the judge voir dire 200 jurors. She voir dired at the outset these jurors who were subsequently voir dired after their records came to light. She sat through 6 weeks of trial with Mr. Davis and Mr. Wall and all of these jurors.
Okay.
And then she brought in these jurors and talked to them at the end while Mr.
Zanini.
Davis and Mr. Wall were present. And her finding is on Record Appendix 57.
Mr. Zanini, I don't want to cut you off on that, but I do want to, because I think there's this case, assuming that you have the authority to get the Corey records, there's this case, and then there are cases going forward. Could you, if you know the answer to the following, could you let me know? There is usually some period of time between when the jury is impaneled, a relatively short period of time, and when, depending on where it is in the day, and when the trial commences. Sometimes the jury is asked to leave because there's some motions or whatever it is. assuming that you have 14, 16, whatever you've got, persons, how possible is it to run a Corey check at that time and get a very prompt response?
It's very possible with that.
If the
limited
judge allows the
number of people.
continuance.
If the judge allows.
Right. And part of the problem is we have this tradition in the Commonwealth, and there's rules, and what you have to say is, oh, the Commonwealth is content with the jury. And once that happens, that's when judges think there's some magic just occurred where there's a difficulty with running the record, and then they'll swear the jury. And so what we need is at least a gap in time, before they swear the jury and say,
Yeah,
bring
but
in
doesn't
your
that
first
create a
witness.
lot of mechanical problems, logistic problems, whatever you want to say? Because normally, as you say, as soon as there are 16 in the box, boom, you can that's it, and then the jury's sworn, and maybe there's a recess if it's been a long time, but maybe not. Maybe you go right into opening statements. But if you get a continuance, you've got to either keep all the rest of the jurors. I mean, you've got to think about this in everyday terms. 10 or 12 other judges are clamoring for those jurors who are in the courtroom, and you're going to have to hold the other jurors then in case something is found. During
Right,
this, so how long a time does it
mechanically and
take?
logistically, you're talking maybe 30 minutes.
So it's about another half hour.
Right.
Well,
20
before everybody gets out of the courtroom, back in the courtroom, it's probably an
You
hour.
can give those jurors a break. You can have the other jurors remain seated in the audience because they may now come up and be selected if there's.
But everything
a
told, it
record.
will be an hour before everybody gets out of the courtroom, and everybody does what they have to do, and you get back in.
Mr. Zanini, and
possible.
maybe I'll ask Mr. Davis if he wants to comment in a post-argument letter. Assuming that the Commonwealth gets access to the Corey records in these circumstances, would it be appropriate for the judge to inform the whole group of jurors who's sitting in the courtroom before the voir dire begins that criminal history records will be run, just to caution, I don't mean caution to give them notice, but just to say, you've all filled in a form, I will have all the forms, I can tell you that's what's going to happen. I've had a motion from the Commonwealth, or for that matter, a motion from the defendant. I mean, it seems to me that the defendant doesn't particularly want to have jurors who biased against the evidence whichever way. And that we will take a short recess. So for any of you, who have such records and you may not have answered the question, when I call your name, please come up to sidebar. I mean, at least that way we may be...
Yes, and there are judges who do that and say, you have the opportunity to step up, and in case your form didn't have some information which it should have had.
No, that's true, but you
Specifically
can
the
actually
criminal
specifically
record.
say what we will be doing in this case is we will be taking a recess before we settle on the jurors,
Right,
so
that could speed the process also.
May I ask you two...
But I don't think they should say, oh, the Commonwealth is going...
No,
has
no.
moved for your records, then people might have some ill will against the Commonwealth.
No, I understand.
Sorry.
Two quick questions for you. This would, if we agree with you, this would apply to all criminal cases,
In any
not
case-
just murder.
Of course.
And what about civil cases? Because wouldn't a juror's criminal background and history perhaps have impact on certain civil matters as well?
Yes.
And so would we do that in civil cases too?
Well, I would suggest someone ought to be running the record to see if jurors are disqualified in any event, because there's a statutory disqualification for a felony within 7 years, and we ought to be, as a system, taking care of that bit of business. And the information that's in there, I mentioned this earlier, if you look at the record appendix and the information that's in the criminal offender record records that start around page 29 and go for a few pages, the information that's in there, by and large, is publicly available. So in a civil case, if I had the resources, I could send my investigator down to the Superior Court Clerk's office and say, here's the list of jurors. And by the way, the jury list, if you go back, and I can't cite the exact statute, but I believe under 234A, the jury list is filed with the clerk of the court a week or two, some period of time in advance of the jurors actually showing up. So if you have the resources, you can get the jury list, and then you can go to the clerk's office and ask for the publicly available information through the clerk's office or various clerk's offices, who on the list go through the alphabetical index, tell me who's got a case file here, let me look at the publicly available file. You can also use, and this is discussed in Roe versus the Attorney General, which I said is 16L letter, and it's 434 Mass 418. But the court notes that there's a fundamental premise that conviction records, of course, are public, but they also note that the Corey statute itself allows members of the public to access significant amounts of conviction data. Any member of the public can go to the Criminal History Systems Board and ask for conviction data within certain parameters and get all of that data. And certainly any member of the public or any civil litigant can go to the courthouse and get even more data by pulling the file and looking at the chronological history, the administrative history of a case. So the only thing that happened here was we used a more efficient means which we're statutorily authorized to do. My final point, because the intent of the prosecutor...
Because your time is up, Mr. Zanini.
Madam Chief Justice, I have another question.
Sure.
however,
Go
if I
ahead.
might.
Why don't you ask your question, Justice Corey?
Mr. Zanini, one of the questions here is whether the judge should have done more in terms of inquiring of the jurors, and specifically referring to Commonwealth versus Caldwell, in which this kind of thing happened. The appeals court said that the judge should inquire as to the reasons why the juror failed to disclose his or her criminal record in the juror form, and that would be helpful to making a judgment about whether this juror should be discharged. Do you think that is one of the things a judge should have done in this case or should do in future?
I really don't think so, because as the judge recognized here, and the judge went through a very thoughtful, methodical process here, which the court, as Mr. Davis said, if you read the transcript, and he agreed at virtually every step with what the judge did, because what she did was obviously the right path to take. Once she gets into their state of mind in terms of non-disclosure...
Well, then you've got potential liability.
Potential self-incrimination. And
Well, let me posit this example. You run a check, you find out one of the jurors, when they were 16 years old, 10 years ago, was convicted of shoplifting and got a $50 fine. You bring that to the attention of the judge. It's not disclosed in the juror form. I take it the judge then needs to make a decision based on that, whether this juror shouldn't be allowed to sit. There may be a million reasons why the juror forgot, because she's 26 and that was 10 years ago. And I mean, there should be no inquiry to make just discharge because you're obviously not suitable?
Well, as you note, there's an inference to be drawn depending on the nature of the offense, the age of the offender, the amount of time that has lapsed, and the inference is whether or not that juror may have a potential bias. And you don't necessarily have to ask why there's a nondisclosure in order to get at whether there's a potential bias. And there are jurors, certainly in our county and every county, who have old criminal case involvement who sit on juries. That's not an automatic disqualification.
So it's not, exactly, it's not an automatic disqualification. So it would be a case of trying to judge whether, based on what the record was, whether there was an inference of bias here?
Correct. Sometimes there's an inference that you can draw based on all of the information. In this case, you have a judge drawing inferences, which you have to defer to based on a voir dire at the outset of the case, based on 6 weeks of trial, based on a questioning of the jurors at the end of the case, and the fact, as you can note in the record appendix, one of the jurors had 6 pages out of 7 of arrests and prosecutions, arrest by the Boston Police, prosecution by the Suffolk District Attorney's Office. I mean, the judge can draw inferences based on her experience with that jury panel.
So should we reject the language in Caldwell which says this is what should be done, that the jurors should be inquired of as to their reasons for failure?
I actually think you should reject that.
Okay, thank you.
Thank you, Mr. Zanini.
You asked a question. I was trying to write it down. Did you want to respond to that at some point?
If you would like to file a letter, that would be fine.
I didn't quite get the entire question. Was made after a juror is selected or for the entire
After it is clear on that there are however many jurors there are on a particular panel.
16.
Well, it depends if it's civil or criminal. But before the parties are asked whether they are content. Thank you, Mr. Davis.